Our last speaker for this afternoon is Ken Melson. Ken works for the Inspector General's Office of the U.S. Postal Service, advising the Office of Investigation on legal matters relating to its administrative and criminal cases. Prior to retiring from the U.S. Department of Justice in 2012, he was a senior advisor on forensic science in the Office of Legal Policy. In 2009, Mr. Melson was named as the acting director of the Bureau of Alcohol, Tobacco, and Firearms and Explosives by President Obama, where he served until August of 2011. Prior to his service at ATF, Mr. Melson was appointed the director of the Executive Office for U.S. Attorneys in 2007 by the Attorney General, where he was responsible for administrative oversight of the 94 U.S. Attorneys' offices and for liaison between the U.S. Attorneys and other federal agencies in the Department of Justice components. He became the first assistant United States Attorney in 1986, a post he held until his departure in 2007. Several times during his career, including on September 11, 2001, he served as a U.S. Attorney. He was also a state prosecutor for 10 years. Mr. Melson is a past president of the American Academy of Forensic Sciences and is a past chair of the Council of Scientific Society Presidents, is chair of the AFS Ethics Committee, and serves on the editorial board of the Journal of Forensic Sciences. Ken?
So thank you all for coming. It's a pleasure for me to be here today. I was actually very surprised that I was asked to come and speak to you since I'm from Washington, and given the Republican caucuses this week, I didn't think that was a very popular position or place to be from. And in fact, I don't think I'll be crossing any walks or streets this week while I'm in Las Vegas, having originated from Washington. You're probably wondering, why in the heck are you listening to a lawyer talking about demystification of forensic science? Most of you probably think that lawyers tend to mystify issues, particularly in court, where we advocate for different positions. Well, let me tell you that in part that's true, because lawyers advocate for their clients. So they argue the position which is most clearly identical with their goal in the trial, and they interpret the law and the facts and science in the light most favorable to their particular client. So you're going to see a difference between the prosecutor's point of view on a case and the defense point of view on the case. And that is something that I think may be of interest to you, because what the lawyers really are the interface between forensic science and the law. We in the courtroom are at that intersection between those two issues. So what I'm going to talk about today is the unusual tension between the law and science. And when I say unusual tension, it's because they don't always work together at the same speed or with the same goals. So when you look at the legal side, when we're trying a criminal case, we want some finality. We want the case to be over with. We want the jury to make its decision, the post-trial motions to be heard, the appellate decisions to be rendered, and then that's it, a final decision. That's not the case, though, with science, because science keeps progressing. It keeps coming up with new technologies. It keeps coming up with new scientific principles, or it looks backwards and reevaluates science from past cases and past decades. So in this particular case, with respect to our jurors and the lawyers, when we go into the courtroom, we're already at a disadvantage. As been mentioned a couple of times, you have all the CSI programs. We're inundated with all these fantastic things that forensic science can do on TV, but can't do in the courtroom. So the jurors start out with a cognitive bias, an expectation bias that they're going to see something great from the crime laboratory. And that is not necessarily true. In addition, there are times when science has looked backwards and seen that there have been fallacies in what our forensic techniques were and or what our forensic opinions have been. So with respect to lead bullet elemental composition, the FBI used to testify that when finding a bullet at a crime scene and a box of bullets in a person's house, they could tell whether that bullet and that box of bullets came from the same batch of lead from the manufacturer. So that narrows the whole relativity of whether or not we got the right person. Well, they found that although the science was right with respect to analyzing the elements of the lead, their conclusions were wrong. They couldn't make that association that they were trying to make. Then we have the hair comparisons. The FBI and the Innocence Project and the Department of Justice are now looking at past cases in which a hair found at the scene was microscopically compared to a known hair from the suspect. And while the microscopic comparison is scientifically valid, the opinions and the probabilities that were drawn from the similarities between the two hairs was not right. And so there have been some people who have been exonerated as a result of that. Bite mark comparisons. There is a question about the validity of some of the testimony given in the past with respect to the identification of bite marks. In fact, the Texas Forensic Science Commission has recommended that bite mark analysis not be admitted in courts in Texas any longer. So we're looking back, and that creates this tension because we thought that our cases were final, that we had adjudicated the issue of guilt or innocence, when in fact now, because of these issues, we're going back and reopening those cases, and we no longer have finality. So not only is the science doing that, but in some cases, the experts are actually recanting their testimony. They're saying, no, what I said back then is no longer true. So in the case of In re Richards, which was a habeas corpus case in California, the defendant was arguing that he should be released because the expert bite mark analyst, the forensic odontologist, came back 10 years later and said, no, my testimony at trial was wrong. He says now that he couldn't testify the way he did 10 years earlier, and the reason was, in great part, because he had looked at more photographs of the lesions on the bodies and the crime scene, and he has more experience. So it's just not science and technology that is progressing. It's also the individual experience of experts in many of the sciences which draw on subjective judgment. So again, it's creating that tension. Then there are new scientific discoveries. We've already heard the professor talk about DNA, the RFLP which was developed. That was greatly enhanced by the development of PCR and STRs in the late 90s. And then we got touch DNA, the one cell that you leave when you touch something. Someone can tell that I just touched that podium. Then mitochondrial DNA, which is not a nuclear DNA, but it comes from the cells. It's a different type of DNA. And we can take a hair shaft without any root on it and determine your mitochondrial DNA. It's not as probative as the nuclear DNA, but it's still probative for defining guilt and innocence in the case. Investigative techniques have improved. You have the CODIS, which is the FBI database, which allows us to put in a forensic sample of DNA from a crime scene and search hundreds of thousands of DNA profiles in the database and get what we call cold hits. In other words, we can find the person because they're in the database. And familial DNA. That is, we're looking at DNA that is very similar to the suspect DNA from the crime scene, and oftentimes can find someone who may be closely related to that person. We then go to that relative, and that takes us to the next person, and hopefully to the actual defendant in the case. So because of these advances, we're getting more convictions. We got cold cases going back years in which we now can get a conviction because of DNA that has been recovered from the individual who was abused or sexually assaulted. And we have greater confidence in our convictions because of the powerful nature of DNA. And it also helps us in other ways. This was an unusual case that I thought I should bring to your attention. This was a British woman who was killed over there, and the defendant was arrested, and he was tried for the murder of the 77-year-old British woman and was acquitted. But after his acquittal, they did more DNA analysis of other items with a more discriminating type of DNA, and they found a profile that matched that acquitted defendant. Now, over in England, they don't have the double jeopardy clause, so they could try him again. And as a result, he is now behind bars as a result of the DNA advances we had. So let me then go to the other side, because advances in science don't only help us convict people and convict individuals who have committed crimes many years past, but they also help exonerate individuals who have been convicted of crimes, but it turns out were unjustly convicted because they were not the perpetrators. So there was this book by BJA, which is entitled Convicted by Juries and Exonerated by Science, which lists these different cases in which people have been exonerated. One case which is of interest today is the case of Stephen Avery, who was a Wisconsin resident accused of a rape that he said he didn't commit. He was found guilty in 1985, and in 1995 they found some scrapings taken from the victim's fingernails and had DNA analysis conducted. But they couldn't exclude Avery. They couldn't exclude him. They couldn't say it was him, but they couldn't say it wasn't him. So it was inconclusive, and he remained in jail until 2003, when hairs taken from the victim that was left by the perpetrator were analyzed, and it came out to be an individual by the name of Gregory Allen, who was already serving a long period of time in the Wisconsin State Penitentiary for sexual assault cases. So he was an individual who was exonerated by science, although convicted by a jury. But here's the twist in this particular case. He was convicted and then exonerated and then rearrested. So I want to talk to you a little bit about the Avery case, which you may be following on Netflix. Netflix has a 10-series program, documentary, on this particular case as to whether or not he killed Teresa Halbach. If you have watched it, you will recognize the music here. All right, so I'll turn it off now. So let me tell you, if you're not watching, let me tell you a little bit about it. So he was released from prison after his exoneration in 2003. All right, he then sued the Manitowoc County for his false conviction and incarceration. He sued him for $35 million. During the suit, they deposed the deputy sheriffs, and at the conclusion of the depositions, he was arrested for the murder of Teresa Halbach. Because of that, he settled for $400,000 and used that money for his defense on the murder case. He worked during this time at the Avery Auto Salvage Yard, which was a large area with vehicles in all states of disrepair, as you see in any type of an auto junkyard. Teresa Halbach worked for the magazine Auto Trader, and she had an appointment with Stephen Avery to take a picture of an automobile he was trying to sell. He turns out to be the last person known to ever see her alive. In addition, Teresa's automobile, 5 days later, after she disappeared, was found in his junkyard. In addition to that, blood was found in the car, blood that was identified not only as Teresa Halbach's blood, but also as Stephen Avery's blood. Her dismembered bones were found in 3 different places, in 2 burn pits and 1 barrel in which things were burned. An expert witness testified to a portion of the skull which showed a concentric circle that looked like it could have been caused by a bullet to the head. And in fact, they found a bullet in one of his garages with her DNA on it, as well as her key in his house with his DNA on it. As a result, he was convicted in 2007 of first-degree murder and for being a felon in possession of a firearm. Now you say, well, that's not surprising, because there was a heck of a lot of scientific evidence to convict him. But that's not the end of the story. So let's look at the blood in the car for a minute. Remember, I said the car was found in his storage area. It was covered up with brush and wood to make it look like it had been there for a while and may not have been easy to recognize. There was blood in the car, one here, right by the steering wheel, a little brush of blood, and then back here in the back of the automobile was found Teresa's blood, either because she was placed in the back of the automobile or parts of her were placed in the back of the automobile and transported to these various places where her remains were burned. How did Avery's blood get in the vehicle? Well, the police identified this, if you can see it, not an insignificant cut on his hand, which if bleeding would have been a reason why the blood would have been in the automobile at the time. All right. So he had a good defense team. The defense team was facing horrendous forensic science evidence against him. DNA that I said gave you more confidence in your convictions in these cases. So he had to come up with a defense. And this is what defense attorneys do, and that's what they're paid to do, and that's what our Constitution requires them to do, is come up with a defense to the evidence that they face, even if the evidence seems to be overwhelming. So his attorney, who's depicted here, decided that the police planted the evidence. Manitowoc police planted the evidence. One of the things that they thought was planted was the Avery's blood found in the car. Now, how would that happen? Well, they went into the clerk's office and found that this box, this evidence box with evidence tape on it, that had been used in the 2005 post-conviction case, had been opened. My God, it's been opened. It's been in the clerk's office all this time. But even more than that, here is the blood vial that was taken from him for purposes of DNA analysis in 2005. All right? So even though the Manitowoc police officer said during this process and during the second post-conviction and exoneration hearing, they went back to analyze and look at the evidence, which would explain the cut on the tape. But Avery's attorney pointed to a hole in the blood tube. That was a red letter day for them, because that showed that there was tampering. So I've got one of those tubes here. No hole in the top, but there's a hole right there. Their theory was the police went with a syringe, put the hole in the tube, sucked the blood out, and placed it in the car. Well, there's the physical evidence, right? But how many of you have given blood at a doctor's office? The way the blood is put in this tube is with a needle, and it makes the hole. All right, so is the jury confused now? Are they mystified by the forensic evidence that's being presented? So there must be a way that you can tell whether or not the blood was taken out of the tube and placed in the car, and there is. Because in these purple top tubes, there is a chemical called, and I'm chicken, so I'm going to say EDTA instead of trying to pronounce that name. All right? So when you put blood in one of these tubes, there's a preservative in it to preserve it, obviously, for later testing. Their theory was that the blood was taken out of the tube by the police, and here's how they might have put it on a swab and put into the car. Now, fresh blood, if it had come, as the prosecution suggested, from the cut on his hand, there would be no EDTA in the blood. So the FBI tested the blood, and they found that there was no EDTA in it at all. There was a question about whether or not they could have found the EDTA. What was the threshold of the testing? So Mr. McCord, who you see wrote this article along with others about a testing process that goes way back to the O.J. Simpson case. If there anybody here who's old enough to remember O.J., they had an issue with EDTA. And he now says that the advance in forensic science is such that you can detect about 1 million times less EDTA than exists in the preserved blood. So they were pretty confident there wasn't any there. The defense attorney, or rather the defense expert, was not so confident in that. She said, I don't know whether that's simply because they didn't detect it or because it wasn't there. But of course, that's true with everything. You know, they argued that they didn't find Avery's fingerprints in the car. Well, maybe they weren't there or maybe they were and they didn't find it. So let's look at one other piece of evidence real quickly, and that was the DNA on the latch of the hood. You all have opened your hood of your car, right? And you put your hands through the grill and you pull that latch and pull it up. Well, that's a nice touch, a nice rub of your finger on that particular latch. And the police found DNA on the latch of that car, which came back to Avery. All right? But here, the prosecutor, like a lot of prosecutors, as well as a lot of defense attorneys and judges, don't know necessarily a lot about DNA or about forensic evidence. And so this is the prosecutor in the case, and he was telling everybody that the DNA was in Avery's sweat. Now, he gave a lot of press conferences, and very inappropriately, and talked a lot about the facts that he shouldn't have been talking about. But he was talking about the sweat in Avery. So they were confusing the issues. So with touch DNA, you have your cells that are sloughed off and left someplace. And very low copy, as we already heard, 1 cell is sufficient. So is DNA a part of sweat, or does sweat have DNA? Well, maybe not, but the DNA can be combined with the sweat, because where is the sweat? It's on your hands where your skin cells are sloughing off. And reported articles indicate that people who are committing crimes may have just dismembered a body, might have sweat on it. But it was an issue that confused people, and they're still arguing today about whether there's DNA in sweat. So the defense put on a great defense. Did it raise reasonable doubt? Apparently not, because the jury convicted him. And he appealed. And both the Wisconsin Court of Appeals and the Wisconsin Supreme Court affirmed the convictions for the murder. Now, there's a lot of controversy about what the makers of Making a Murderer, the documentary, left out of the documentary, because there's a lot of evidence they didn't talk about. There was a lot of explanation they didn't use in the documentary. But what they said is probably correct. You know, this wasn't a trial, it's a documentary, all right? So you couldn't put it all in. But also, it was a documentary on how the defense develops a case, how the defense argues its case before a jury, what theories they come up with. So they weren't necessarily trying to convince people of Avery's innocence. But nevertheless, almost 130,000 people around the United States signed the online We the People petition at the White House, asking the president to pardon Avery for the crime. Of course, President Obama couldn't do that, even if he wanted to, because there was no offense against the United States. The Wisconsin governor would not pardon him either. So what's going on now? He's got a new attorney, and this is great. Kathleen ZELLNER holds herself out to be one of the best post-conviction exoneration attorneys. And she has indicated that since 2007, there have been significant advances in forensic science. And not everything had been tested, she says. Now, she won't tell us what the new tests are or what the advances are. She's in effect saying, let's wait and see. And maybe she'll come up with something. But again, it leaves the criminal justice system in an uncertain position. Will Avery's case ever be final for purposes of the criminal justice system, or will new evidence someday come up with new science that'll prove that he is actually innocent? So this really takes us back to 2004 when I was president of the Academy, and our theme that year was Truth and Justice in the Balance, forensic scientists as the counterpose, because forensic science really does even the playing field. And that's why science is so important to the criminal justice system, to even that field out. Thank you.